Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Ashashamina binti Muhammad Razib, and I'll be explaining on the drawing of maritime boundaries, especially on the exclusive economic zone. The breadth of the exclusive economic zone shall not extend beyond 200 nautical miles from the baseline from which the breadth of the territory sea is measured under Article 57 of UNCLOS 1982. In the case of archipelagic state, the breadth of the exclusive economic zone shall be measured from the archipelagic baseline drawn in accordance with Article 47. The exclusive economic zone, which is an area beyond and adjacent to the territorial sea, is subject to a specific legal regime established by the 1982 Convention. In the exclusive economic zone, the coastal state has first, sovereign right for the purpose of exploring and exploiting, conversing and managing the natural resources, whether living or non-living, of the water superjacent to the seabed of the seabed and its suboil, and with regard to other activities for the economic exploitation and exploration of this zone, such as the production of energy from water, currents and winds. Second, jurisdiction with regards to establishment and the use of artificial islands, installation and structure, marine scientific research and the protection and preservation of marine environment, and lastly, other rights and duties provided in the UNCLOS 1982. Now, it has to be pointed out that a number of coastal states have chosen for the time being not to establish an exclusive economic zone. Instead, some of them claim or continue to claim a fishery zone, although the 1982 Convention does not provide for such zone. And in the fishery zone, the coastal state exercise sovereign rights limited only to marine living resources as compared to the larger entitlement in exclusive economic zone under 1982 Convention. The existence of such zones has been generally accepted. As with exclusive economic zone, the outer limits of the fishery zones shall not extend beyond 200 nautical miles from the baseline. The goals of achieving an equitable result when establishing the boundaries of a maritime zone appeared in the Truman Proclamation of 1945, and since then it has become a customary law when dealing to maritime boundaries delimitation. Also, we can see from the Jan Mayen case, where the court state that the statement of an equitable solution as the aim of any delimitation process reflect the requirements of customary law as regard the delimitation of the continental shelf and the exclusive economic zone. That's all from me. Thank you.
So continental shelf is a natural seaward extension of a land boundary. So this seaward extension is geologically formed as the seabed slopes away from the coast, typically consisting of a gradual slope, which is a continental shelf proper, followed by a steep slope, which is a continental slope, and then a more gradual slope leading to the deep seabed floor. So these three areas, collectively known as the continental margin, are also rich in natural resources, including oil, natural gas, and certain minerals. Besides, the Law of Sea Convention allows a state to conduct economic activities for a distance of 200 nautical miles from the baseline or the continental margin, where it extends beyond 200 nautical miles. There are two methods to determine the extent of the continental margin under the Law of the Sea Convention, which is the first method is by measuring geological features using what is called the Gardiner formula. So by measuring the thickness of sedimentary rocks, the age of the shelf is drawn where the sedimentary rocks become less than. Moving on to the decided case, which is Netherlands and Denmark had drawn partial boundary lines based on the Education principle, which is A, B, and C, D. So an agreement on further prolongation of the boundary proved difficult because Denmark and Netherlands wanted this prolongation to take place based on the equidistant principle, which is B and E and DE, whereas Germany was one of the view that together these two boundaries will produce an inequitable result for her. So Germany stated that due to its concave coastline, such a line would result in her losing out on her share of the continental shelf based on the proportionality to the length of its North Sea coastline. So the court had to decide the principles and rules of international law applicable to this delimitation. In doing so, the court had to decide if the principles exposed by the parties were binding on the parties either through the treaty law or customary international law.
The contiguous zone is the zone contiguous to the territorial sea where a coastal state may exercise control for preventing and punishing infringement of its laws and regulations concerning custom, fiscal, immigration, or sanitary matters within its territory or territorial sea, as well as removal of archaeological and historical objects found at sea. Article 33 of the 1982 Convention is the sole article dealing with the contiguous zone and sets its limits as not extending beyond 24 nautical miles from the baselines from which the breadth of the territorial sea is measured. The 1982 Convention does not contain any provision for the boundary delimitation of this maritime zone. It may be noted that such a provision was included in the 1958 Geneva Convention on the Territorial Sea and the contiguous zone. Now, let's move on to the case relating to the contiguous zone, which is the Enrica Lexi case. The incident took place on the 15th February 2012 when Enrica Lexi, which is an Italian flag shipping vessel, came across an Indian fishing vessel named San Anthony. Enrica Lexi reported a piracy attack when it was sailing close to the Indian border in the Indian contiguous zone. The question raised in this dispute was whether India could exercise its criminal jurisdiction given that the incident took place beyond its territorial waters, which extend to the 12 nautical miles from the shore. Exercise of criminal jurisdiction in territorial waters is mentioned in the Article 27 on the United Nations Convention on the Law of the Sea. The place whether the incident took place, which is at 20.5 nautical miles, is what the convention terms as the contiguous zone. Here, a state can only exercise necessary control for violation of the customs, fiscal, immigration, and sanitary laws. The convention is silent if criminal laws can be extended to the contiguous zone. For India, the 1976 Maritime Zone Act extends India's criminal jurisdiction up to 200 nautical miles. When the matter was raised before the tribunal, Italy argued that India's law was contrary to the provisions of the United Nations on Law of the Sea. However, given that the Marines were entitled to immunity, India was directed to cease its criminal jurisdictions over the matter.
I'm going to be covering the territorial sea segment when we talk about the rules of drawing maritime boundaries. So the first thing that I would like to say is to talk about is Article 3 of the Convention. Now, Article 3 states that every state has the right to actually draw the breadth or like to establish their breadth of territorial sea as long as it doesn't exceed 12 nautical miles and that the baseline is according to what the Convention has said. So moving on to Article 15. Now, this Article 15 is actually commonly believed to be a customary law because it coincides by applying the method of median line to every point which is equidistant from the nearest point of the baseline for the delimitation of the territorial sea. So when there is no agreement between that, when there's no agreement between the states. So if there is an absence between the state parties that is in question, they cannot or they are not allowed to draw or like to extend their territorial sea more than the median line provided. So 12 nautical miles is actually a really short distance when we talk about territorial sea. So we don't see a lot of cases on frontal delimitation cases when we talk about this, but we do see it when the two states shares a bordering straits, for example Malaysia and Indonesia and Singapore. But for these three countries we actually came to an agreement, for example Malaysia and Indonesia in 1970s. So how we came to an agreement is that they actually applied the equidistant as the main method of delimitation. So one of the examples or the cases that I can put out is the Kenya-Tanzanian agreement. So the course of the final boundary combines numerous delimitation methodologies. So the first boundary segment is equidistance between two of the claimed strait baseline. So segment A has actually been developed by drawing by drawing an arc from the point X. Now this arc was actually an artificially established point. So segment B to C is actually an equidistant between selected coastal point, one from each country. So the seaward extension of the boundary from point C based on the parallel of latitude. So thus the boundary represents an agreement which has been established in accordance to the equitable purposes and actually has satisfied both countries. But in any case, it seems that the regard of delimitation of the territorial sea, a practical approach to facilitate the negotiation might be to start by drawing an equidistant line and then consider it the light of special circumstances of the case in order to proceed eventually to all adjustment in which all parties will agree on. Thank you.